7 p.m. Thank you. We're meeting via Zoom and we'll be following our regular protocol. The meeting is, as you just heard, being recorded for audio and visual content and is under the control of a Zoom host. I understand our Zoom host will be leaving the meeting at 8:15, at which point I will assume that role, just so everybody is aware of that. To ensure optimal sound quality, the general rule for the meeting is that everyone remain on mute. Commissioners and staff generally remain muted except when speaking or voting, and will generally have their video turned on throughout the meeting. Applicants, their representatives, and the general public may leave their video on or off, but will be asked to turn their video on when speaking. That said, no one for whom video is not an option will be precluded from speaking at the appropriate time or from listening to the meeting. All participants should state their name for the record each and every time they speak. Please raise your hand at the appropriate time using the raise your hand feature located at the bottom of your screen to let me and the host know that you wish to speak, and I shall recognize you. Please do not speak until you're recognized. Members of the general public may only speak during those portions of the meeting set aside on the agenda for citizens' comments, and there are two such opportunities, one near the beginning and the other toward the end of the meeting. Individual applicants, permittees, and violators whose names appear on the agenda and/or their representatives will be invited to speak when that agenda item is discussed. If any party has documents to submit to the commission which were not distributed in advance of the meeting, please indicate when that item comes up for discussion that you wish to submit them. You must hold them up to your camera so that the commission and all members of the public can view them, or alternatively, you could perhaps share your screen. You will be required after the meeting to submit an electronic version of any documents, either in PDF format or an acceptable photograph via email to the Thompson Inland Wetlands agent to ensure that they're included in the permanent records of the commission. I should remind everyone that if a member of the general public tries to communicate at a time other than that set aside for citizens' comments, or if anyone in attendance speaks out of order in a disruptive or inappropriate manner, or for an inordinate length of time, they may be prevented from doing so, and if necessary, ejected from the meeting at my discretion. Those are the preliminaries. I'm now going to call the roll. Commissioners, please respond by saying present. Commissioner Langer.
Present.
Commissioner Morano.
Present.
Commissioner Obert. Absent Commissioner O'Neill.
Present.
We have staff members present this evening: Margaret Washburn, our duly authorized Inland Wetlands agent; Amy St. Ange, first selectman and Zoom host; Gloria Harvey is our recording secretary. We do have a quorum. The next item on the agenda is the seating of alternates, and is Greg Corso as our alternate member. Greg, are you present? I think you are.
I'm here.
Wonderful. Well, seeing as all regular members of the commission are not present at this meeting, it is my pleasure to seat you. So you can, you're not only welcome and encouraged to participate in the in discussions, but to vote as well, if and when we cast votes. The next item on the agenda is to approve the minutes of the October 8th, 2024 regular meeting. And for that, I will share my screen. Let's see how I can do this. Screens. Why am I not? Okay, let's see. I think I need to do this. Okay. I am indeed screen sharing. And what I want to do is I want to make this larger for everyone. There we go. Now I'm going to do that this way. Okay. These have been posted, so I'm assuming everyone has had an opportunity to review them. Do commission members or staff wish to offer any corrections to these minutes? If so, and if acceptable, the recording secretary will please note and incorporate those corrections. Do we have any corrections, any amendments to the minutes, any additions, omissions? Hearing none, I'll entertain a motion to approve the minutes of the October 8th, 2024 regular meeting.
I'll make a motion to approve the minutes.
Thank you, Commissioner Morano, for making that motion. Do I have a second?
I'll second.
Thank you, Commissioner Langer, for seconding. All those in favor?
Aye.
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 All those opposed? The minutes of the October 8th, 2024 regular meeting are accepted and approved as written. This now brings us to the approval of the minutes of the special meeting of the site walk of November 2nd, 2024. Do commissioners or staff wish to offer any corrections to these minutes? I had only one correction to offer at almost at the very bottom of the first page. Again, I apologize, this may be the high school English teacher speaking, but is it a detention basin or is it a retention basin?
I think it's a retention basin.
Yeah, detention is a high school thing. I guess that was sort of a trigger for me.
Once announced, one the verb, maybe it is being detained, but
So,
it's intended to be retained. It's a retention basin that's detaining the outflow.
yeah, right. Okay. Are there any other corrections to these minutes that commissioners and staff wish to offer? Hearing none, I'll entertain a motion to approve the minutes of the special meeting of November 2nd, 2024.
I make a motion we approve the minutes of
Thank-
November 2nd special sidewalk.
Thank you, Commissioner
I'll
O'Neill.
second that.
Thank you, Commissioner Morano, for seconding. All those in favor?
All right.
Aye.
Aye. All those opposed? Okay, that the minutes of the special meeting of November 2nd, 2024 are approved as submitted. The next item on the agenda is citizens' comments on agenda items. And please note that this is an opportunity for members of the general public other than applicants, violators, or their representatives to inform the commission of any questions, concerns, or observations relating to specific agenda items. Further discussion of those items will be reserved for those portions of the meeting specified on the agenda. Are there any comments on agenda items that members of the general public would like to share at this time?
Chair, you have a request by Ms. Clark, it appears.
Thank you, Commissioner O'Neill. Here I am looking at my agenda. Ms. Clark, you are recognized.
Thank you. Valerie Clark, Ulm Road. I noticed under your correspondence that you received a request about the Sustainability Commission, and that was the first I had heard of it, and I'm interested in learning why it's being restricted to certain people. So hopefully we'll get that answer later on, but I wanted to voice my concern right now. Thank you.
Thank you for that good question. It's most welcome. I look forward to learning more about this initiative. Other citizens' comments? If none, then the commission will now consider pending applications. What appears on the agenda as an old application is actually a new application. This is IWA 24037, Wojciech Sudika, 1574 Riverside Drive, map 55, block 65, lot 14, new 70,200 square foot building, associated driveway and drainage system. To be clear, this application was received on October 8th, the date of our last regular meeting. The statutory date of receipt is the regular meeting following the date the application was submitted. Therefore, the commission cannot act on this application tonight. That said, I don't know if Daniel is here. Or if the applicant is here, would like to share any comments. Daniel, you're recognized if you would like.
Yes, good evening, everyone. Can you hear me?
Yes, we can.
All right, thank you. For the record, Daniel Blanchette, J&D. I'm a licensed civil engineer. I think the commission is pretty familiar with this project. I apologize I could not attend the site walk. last Saturday. But I would be happy to answer any questions. Since the previous meeting, the big thing that we did was we hired a soil scientist, Joe Thoreau, who investigated some of the wetlands that had been disturbed. He prepared a report outlining some strategies for restoration, remediation. All those have been added to the site plans, and that's pretty much it.
Thank you, Daniel. Do commissioners have any questions or comments about this application as it stands? I noticed, Daniel, you've submitted a revised site plan, I believe, that indicates that the movement of the silt fences further back from the wetlands. Is that right?
Yes, sir. Yeah. So I had a conversation with the agent, Margaret Washburn, late last week. We had a discussion about the silt fence. Right now, currently, some of the silt fence is within the wetlands, as some areas were inadvertently disturbed. My client, moved the silt fence further into the wetlands. And once those areas have been restored, of course, we will pull that silt fence back to the edge of the wetlands. And the site plans have been revised accordingly.
Thank you. Is there any documentation that any members of the commission would like to review at this time? Margaret, did you want to share with the commission and Daniel the conditions that you had? These are included in your report. I don't know if everyone has had a chance to see that, but what we might want to be paying attention to moving forward with this application.
I drafted 3 special conditions for consideration by the commission. The first is the applicant is hereby required to retain a soil scientist to supervise the removal of fill from the 2 areas where unpermitted wetlands fill is to be removed. Because at the last meeting, Daniel suggested that it would be appropriate for me to be doing that, and I don't think it is, because I think it's a conflict of interest for me to be working in that capacity for the applicant. The second special condition is when the wetlands restoration has been completed, the applicant shall contact the wetlands enforcement officer via email for an inspection. The third one is the applicant shall complete the wetlands restoration prior to conducting any other construction activities on the site.
Thank you. Thank you.
Could I respond, please?
Please, Daniel, I was going to ask you if you had any comment.
Yeah, so with the restoration, I understand that's a goal of the commission, but a lot of work is going to will need to be performed to access that area. There's some very large piles of stone that will need to be crushed and removed. It's not possible, and I think if you look at Joe Thoreau's report, it discusses this. It's going to be difficult to restore those areas without doing some additional work. Otherwise, you need to have machinery driving into the wetlands. Those disturbed areas are kind of blocked at the moment. And so I just have a concern about that last item.
Thank you. Other commissioners have questions or comments on that? And am I right in thinking that Mr. Thoreau would be the soil scientist who provides the removal of the fill?
Yes, sir.
Any other questions for Daniel while he's here with us tonight regarding this application? Don't go away, Daniel. Very good. If not, this brings us to another new application. This is WAA 24039 David Malo, if I'm pronouncing that correctly, 17 Bicola Road, map 116, block 24, lot 20, a new single-family dwelling house, septic system, and well and upland review area, and a previously developed lot. My understanding is that this application is on hold pending NDDH approval. That said, so the commission can't really do anything with it tonight. That said, Daniel, you're here. This is one of your projects, I think. Do you have any comments to share about this application?
Yes, sir. Yeah, we received some comments last week from the health department. We have to move the well a little bit to the, I guess it would be west. I expect NDDH approval certainly before the next meeting.
Excellent. Thank you. Other commissioners have any comments or questions for Daniel or about this application?
I'm a staff member that has something to say, I think.
Of course, that includes staff members.
This is, it's an agent approval application, I believe.
Yes, it is.
And so as soon as, we don't have to wait for the next meeting. The chairman has had a chance to review everything. And as soon as I get the only outstanding documentation that's we're waiting for is the health department approval, I'll be able to issue the approval immediately and also run the legal notice in the shopper's guide. So we don't have to wait till the next meeting.
Good to know. Thank you. The applicant should be pleased to hear that. Thank you. Other comments? If not, that brings us to a declaratory ruling 240. I believe it's 24020. Is that right, Margaret? It's listed as 24024 on the agenda. The application number is 24040. This is M. Laprise Logging, care of Chris, if I'm pronouncing that one correctly, 0 Bull Hill Road, map 23, block 105, lot 43, timber harvest. There has been a lot of back and forth about this. My understanding is that the fundamental issue concerns outstanding temporary right-of-way agreements from 2 private landowners on the discontinued portion of Bull Hill Road. Are there any representatives or applicants, representatives for this project present at the meeting tonight?
Yes, I'm Chris Cassidy. I'm here tonight.
Hello, Chris. Welcome. Thank you for joining us.
Yeah, thanks for having me. And I think you hit the nail right on the head. The last 2 items of business that we're looking to attain is a signed temporary right-of-way agreement for the discontinued portion of Bull Hill Road. Otherwise, I'm here to field any questions you may have about, the operation we have tonight. Margaret and I had an extensive site walk out there, and I guess I'm here tonight seeking a conditional jurisdictional ruling that once we get those 2 documents, we can go ahead.
Well, do other commissioners have any comments or questions?
Commissioner Dustin, thank you. I'd be interested in hearing our inland wetlands agent's assessment and recap of the dialogue she had with the applicant and as respects this application. Margaret, if you could.
Yes, I'm just reviewing my notes here.
Okay.
Well, the application needed some revision and it wasn't 100% complete. So I issued an extensive review for which Mr. Cassidy said thank you and mentioned the issues at hand, most of which have been resolved at this point. And we did the long site walk and actually met one of the landowners on the abutting land to the north, Gary Clavette, when we were doing the site walk. And since we did the site walk, Mr. Cassidy obtained the written right-of-way agreements from Mr. Newman and Mr. Clavette to the north to use their property to drive around to get to a part of the uplands that he couldn't otherwise access. I found out from a forester at DEEP that Matt Laprise's license seemed to have been expired, but Nick Zito of Deep let us know through an email that they have been, the DEEP foresters have been busy fighting forest fires and doing other routine work, which delayed the update of their list of license to be renewed. And so Mr. Zito wrote, "Your license is good for renewal," to Matt Laprise. So that issue has been resolved. The only outstanding issue is the private landowners on the discontinued portion of Bull Hill Road. And we're not under, the commission is not under any duress with a timeline to approve this application conditionally. And so I know that the applicant wants to get going because the natural diversity database folks put a constraint on the time of year that they can conduct the forest management practices because of the species that are there. But I don't think you're under duress, and it's a commission, okay, it's a commission decision and not my decision, but you're not under any duress to issue a conditional approval.
Sure.
You might want to wait until the two private landowners on whose property the logs have to be driven out through have had a chance to review and sign a right-of-way agreement.
Commissioner O'Neill.
Yeah, I want to follow up. Thank you very much for that recap of the and update on the components. So, in your professional opinion, Margaret, do you think that the extension approval of this application would have any material lasting effect on the inland wetlands and wildlife associated with this property? And do you see any meaningful reason why it should not be approved?
No, I don't understand the first part of your question.
Okay, well, is there any impact? By us approving this, will there be any impact from that activity in the wetlands?
It
that
shouldn't be impacting the habitat of the species of concern described in the database review.
Okay.
Because Chris has carefully marked the harvest to stay 50 to 75 feet away from the edge of the wetlands. And the bird species not present at this time of year.
Right, which is spotted turtle and whippoorwills are the concern.
Okay, so essentially,
and so I don't see any reason not to approve it. It's just that I think,
Margaret, might it not be prudent to wait till the right of way has been signed off by the landowners that are affected?
right. I agree. I suggest that, but again, it's not my decision.
Sure. Well, I think to my question, though, I wasn't addressing the timing issue, and certainly I agree with the commissioner's suggestion about concurrence by adjoining property owners. But I'm just wondering. My question was to any impact, which you've answered. So thank you very much.
You're welcome.
If I could just add, there was a timber harvest that utilized this same landing a couple years ago, and none of the landowners had any issues then with the trucks going by the road. There's no wetlands or anything on these right-of-ways, and I am certainly willing to not start anything until we have those right-of-way agreements into the town. That's certainly our position.
Chris, this is Chairman Dustin. Have you been in contact with the two landowners who have yet to?
Well, this just kind of came to light this morning, and I did email them both the agreement, the proposed temporary right-of-way agreements, and my contact information. I didn't hear back today, but I certainly will be diligent in following up on that.
Mm-hmm.
I might add something in the supplemental Zoom documents. There's an email from one of the abutting landowners who owns part of the discontinued road. His name is Don Charzan. There's an email from him, and there are a couple of draft agreements that Chris Cassaday prepared to email to them. And Chris, did you email those folks today? Both?
Yeah, they were all attached on that email, Margaret. Yep.
Okay, so I believe Mr. Charzan was out of town today and not returning until tonight. And I don't know about the folks whose last name is Betty.
Mm-hmm. trying to bring this up.
It's the
I think you're on
next,
page 135.
Yeah, I'm just trying to manipulate it. Oh, these are the supplementals,
yeah,
which is what we were. There we go. The supplemental is 9 or so.
that's a revised form we received today with the applicant was listed as Matt Laprise, and he didn't sign the original application, but the second version has his signatures on it.
And this is the email from Don
Charzan.
Sam. Okay.
And these are the draft agreements that neither party has responded about yet.
Okay.
And then there are the two signed agreements from Mr. Clavette and Mr. Newman.
Very good. Okay. And this is the foresters.
Right, about the license.
And that issue seems to be, if not resolved, then practically resolved. I'm going to,
Commissioner Dustin?
yes, Commissioner O'Neill.
It appears, based on the information that's been presented by the applicant and the data that was submitted to the commissioners as far as the public record, there seems to be no reason not to approve such a application. I suggest we, maybe move to I'd recommend that we do approve it. I'll put that in as a approval, subject to conditions that the corresponding landowners are signed off and otherwise meets the requirements.
Okay. In that case, I will entertain a motion to approve this application conditionally on the two outstanding temporary right-of-way agreements being signed and submitted by the I cannot remember, Betty and
Charzan.
Tarzan. Yes, that's a hard one. There are almost no vowels in that.
That's right.
I make that motion.
Thank you, Commissioner O'Neill. Do I have a second for that motion?
I'll second.
Thank you, Commissioner Langer. Discussion.
Well, it appears we've thoroughly vetted it. The details are provided in this application prior to, and there, as you note, there are conditions that we suggest that must be met in order to go forward, which Mr. Casadri apparently has in hand, and as he mentioned, it was worked in the past, so this is nothing and not a new activity for this vacant property. So seems to be everything in hand. So I see no reason why we shouldn't approve it.
Margaret, can I ask for just a point of clarification? For a conditional approval like this, once we get the signed agreements and those are presented to you, then do you issue the approval? Is that how it works? So
Right, I'll issue a notice in the for the newspaper after this meeting that will say that you approved it conditionally, but the actual approval will not be issued until we get the signed agreements.
okay. Okay, and but that needn't wait until the next regular meeting.
No.
Right? Okay, good.
Yeah.
In that case, I will call for a vote on the motion, which is to approve this application, and this is DEC 24020, conditionally on the submission of signed temporary right-of-way agreements. All those in favor?
Aye.
Aye.
All those opposed? The motion carries. Thank you.
Yep, very good. Thank you.
Thank you.
Chris, for being here. Applications received after the agenda was posted. We have none listed here on the agenda. Permit extensions, changes, we have none listed here on the agenda. That brings us to active violations and pending enforcement actions. Of those, we have one.
But do we have any, excuse me, Commissioner Chair, are there no applications received after the agenda was posted, Margaret?
There are, in a
Oh,
sense.
okay.
I was postponing discussion of that to other business,
All right.
which where it
Thank you.
appears on the agenda rather than asking for a motion to revise the agenda.
Sorry. Thank you.
No, not at all. Thank you. I wondered that myself. So VIOL 23013 permit IWA 21028 Wojcik Sudika 1574 Riverside Drive, map 55, block 65, lot 14, show cause hearing for grading work that has exceeded the scope of work shown on the approval plans. My understanding is, or my view perhaps, is that we cannot, because we cannot act on the most recent application, there is no cause to close the show cause hearing and lift the cease and desist order at this time. I would entertain a motion to continue the show cause hearing until our December meeting, at which point we can hopefully wrap all of this up together. So I'll entertain that motion, but if commissioners have other thoughts, questions or concerns, I would also welcome those.
I'm willing to make a motion that we postpone the show cause hearing.
Thank you.
I'll second that.
Thank you, Commissioner O'Neill, for seconding that. All those, any discussion?
I think that she might be looking for the word continue rather than postpone.
Okay.
Sorry, I meant continue.
Thank you.
Thank you. All those in favor of continuing the show cause hearing?
Aye.
Aye.
Are those opposed? Then the hearing is continued. Thank you very much.
Did anyone second that?
I seconded.
Yes.
Commissioner O'Neill.
Oh, thank you.
Commissioner O'Neill, sorry, I should have been more clear.
Commissioner Morano made the motion. This brings us now to other business. And so here we are turning our attention to IWA 18027 Strategic Commercial Realty Incorporated, Zero Aquatic Town Farm Road, map 147, block 14, lot 14, pond expansion. This was discussed at our last meeting. Margaret, do you want to quickly bring us up to date to where we are?
Sure. I'm looking at my report.
I mean, while you're
on October 8th, I was contacted by Madeline Smith, attorney representing the pond expansion, with a new special permit filed with the Planning and Zoning Commission to connect the pond in Thompson over the town line to connect to a pond in Putnam. The existing edge of the pond is in Thompson, short of the town line, which would require more grading. I told Ms. Smith that it's my understanding that the work would require a permit, and Ms. Smith stated that the pond, quote, wasn't done yet, unquote, and that there's no work in wetlands, and that she didn't believe the work would require a permit. However, it appeared that this work is beyond the scope of work shown on the approved plans for IWA 18027. I reached out to Rich Roberts, town attorney, who sent an email on October 29th, which said in part, while it may not have any direct physical impact above the surface, there may be subsurface impacts on the hydrology of the wetlands by creating a pond that's significantly larger than had originally been approved. The wetlands where the existing pond has an outlet are one of the 10 most important wetlands in Thompson. I believe the water from the outlet flows into a flood zone and then into mapped natural diversity database habitat in one of the 10 most important wetlands in Thompson. A portion of the subject property is subject to the mapping of the natural diversity database. And there's a question about whether the outlet as constructed for the 6 plus or minus acre pond would possibly fail during a 100-year flood after the size of the pond is expanded, unless the I'm not sure whether the question of the size of that outlet should be revisited by the the pond would expand significantly in size. And so we didn't have an application before us before this project went to the Planning and Zoning Commission, and it came to our attention that the Planning and Zoning Commission approved the application revision that they got. And so there's been some internal conversation about procedure and that Wetlands should be signing off first, but because we didn't get an application, it didn't happen. And so Chairman, I believe Chairman of the Planning and Zoning Commission and our Chairman Dustin are going to be having a meeting next week to talk about doing what's trying to get Wetlands to sign off in general before Planning and Zoning Commission, because they also signed off on another project that didn't come to us, Wetlands Commission first. And so a couple of projects got approved by PZC at the last meeting without Wetlands prior approval. So that's the other business aspect of this that we had before us before we received an application. So Chairman Dustin, do you want me to go on to talk about the application that was received after the agenda was posted?
You can do that. I will, since you brought it up, I am meeting with the Chair of Planning and Zoning tomorrow, in fact, to talk about coordination in general. And you could, so my understanding that this project, so it was originally approved under IWA 18027. The most recent application exceeds the scope of the work originally permitted. And this application was received quite recently. And we can't, that is, it was submitted quite recently, but we cannot receive this application tonight, is my sense, for two reasons, if I understood your report. One is that it is not properly filled out, and the other is that the fee has not been paid. Is that correct?
Yes, I'll give you, I can give you my comments on what you just, follow up to what you just said. Today, an application was received via email without payment from attorney Harry Heller for Strategic Commercial Realty, Inc., doing business as Rawson Materials for Zero Aquatic Town Farm Road to expand an existing pond. The pond excavation was originally approved under IWA 18027, and in May, I received a postcard stating that the work had been completed in December of 2023. The application was sent via email at 4:02 p.m. on Friday, November 8th. Town Hall was closed on Monday, November 11th for Veterans Day, and so the application came in after the agenda was posted, and so it is not on the November 12th agenda. We didn't receive any fees, and our regulations are pretty explicit about needing an application, a plan, and fees for an application to be complete. And I think the problem that Chairman Dustin referred to is that the base form has two boxes checked. One is for a jurisdictional ruling, and the other one is for a permit for an individual lot. The form, however, states check one, but two boxes are checked. And so two boxes shouldn't have been checked, and this needs clarification. And I recommend advising the applicant to submit a revised application to show only one box checked for a permit for an individual lot, and to delete the request for a jurisdictional ruling. I don't think the commission needs to take any action tonight, and we need clarification, more information, and the fees to be paid. And also, we need to hear from our town attorney who has been contacted. So I feel like we need more information from the applicants regarding the, from maybe from some specialists about the potential impacts on the jurisdictional resource areas.
Thank you, Margaret. That's very helpful. I know that Attorney Heller is here. I would like to hear from other commissioners. How you think we might proceed with this?
Yep, I have a comment.
Sure.
Commissioners, I happened to attend the Planning and Zoning Commission meeting, which lasted over 4 hours, which was referenced by the Inland Wetlands agent. And I find it particularly disturbing, disappointing, and a breach of a number of protocols that a Planning and Zoning Commission, which exists in our town, would approve something without the required prior approval by the Inland Wetlands Commission, a commission that's established under the Inland Wetlands and Water Courses Act, a federal act, and adopted by the state of Connecticut and pushed out of the towns. This behavior is inexcusable. This is a repeat activity. Commissioner of the Planning and Zoning Commission has been in place a number of years and is well aware of this, as is the Cindy, the Planning and Zoning Enforcement Officer. I was very disappointed to hear it, and although I couldn't comment at the time, she recognized it and acknowledged it, which are not reflected in the minutes of the written minutes of the meeting for the Planning and Zoning Commission. If you do have time to spend 4.5 hours to listen to the meeting, you'll find that she did acknowledge that she failed to submit it, and she just forgot. So I guess we're all human. So I just want to express my disappointment in the failure of the Planning and Zoning Commission to adhere to our required protocols. Thank you.
Thank you, Commissioner O'Neill. It's very interesting to hear that for those of us who are new to this situation. I appreciate it. Commissioner Morano, please.
Having a bit of perspective on all of this, I must say it's a bit shocking and disappointing because in all of the years up to probably our last enforcement officer, we would have any application was submitted with 3 maps. One went to inland wetlands, one was meant for inland wetlands, one was meant for the building office, and one was meant for planning and zoning. And we had stamps that we stamped all 3 maps, and we held all of that through our meeting. And when they were approved, the chair had to sign each map, and then they were distributed to those different commissions. And they were not allowed to be entertained by the other commissions until they received approval from inland wetlands. So this is a huge deviation from tradition.
Mm-hmm. Thank you. Other commissioners wish to comment?
I'm all set.
Well, I will, speaking more to the application, I'm concerned that there is a potential impact on one of our 10 significant wetlands. It seems to me that this is the same project for which inland wetlands, an inland wetlands permit was originally requested and granted, and we were told that it was complete, and now it's not complete. And what we're seeing is a significant increase in scope. So I think the request for a new individual application, not just a jurisdictional ruling, is justified given the need for close scrutiny in this case. There is a
I agree. It's a different project, really.
That's right. That's right. And the hydrological impact of the creation of a water body of that scope is something that we need to take into consideration, which we can do if we ask for an application that is appropriately revised and includes the further information that we need. I know attorney and a representative of the applicant is here. Is that right?
There are 2 representatives. We've got an attorney and we've got John Follies, who's the engineer from Boundaries who prepared the plan.
Wonderful. Either or both of them are welcome to speak. We've been doing a lot of talking.
Bill, did you want to go first?
I'd be happy to. For the record, I'm Attorney William McCoy. I'm a partner in the firm of Heller, and McCoy, who represents the applicant in this matter. There are a couple of things that I think are important for the commission to understand. It was described that 2 boxes have been checked off in the application and that somehow that's inappropriate. Actually, what is common in many situations is this application is made in the alternative. And the alternative is for a jurisdictional determination that this is not something that requires a permit, or in the alternative to invoke the jurisdiction of the commission if in fact it's determined that it is appropriate. And let me explain that. There was a description about the 2018 permit being completed. The reference to that is a card that was apparently sent in indicating that the proposed date of completion would be, I believe, in January of this year. The reality is that that permit is still active and has been worked on up through and including August of this year. So that permit is still in place. And I think it's important to understand that under state statutes, the original permit, while it purported to be for a period of 5 years, in fact is covered by section 22A-42A of the Connecticut General Statutes that provides that permits issued after July 1, 2011, but prior to June 10, 2021, are good for a period of 14 years. So that the permit itself has not expired and the permit work has not been completed as of this date. Now, having said that, there is additional work that is proposed, but I want to be clear that because there was comment on the record to this effect, the applicant has not completed the work under the original 2018 permit, and that permit is still an active permit under the state statutes. The second issue relates to the pond itself, which requires a jurisdictional determination as to whether or not that pond is in fact a jurisdictional water body. It is a pond created exclusively out of the excavation of material, which does not have any of the component parts of a water body under either the Clean Water Act or the DEEP regulations. And so I think there is an issue for the court to consider, for this commission to consider relative to whether or not the jurisdiction is implicated in not only the original permit, but the expansion or the modification of that permit as well. Now, Mr. Felice is here and can provide some further detail with respect to his site inspection, but I think that covers why the application, at least in form, is appropriate. Now, as it relates to the fee, the understanding we had going into this matter was that we were going to deliver the fee tonight to an in-person meeting. We discovered, or were told this today, that this was going to be a fully Zoom meeting. And so I have before me, and if you wish, I can hold up, we have the check from my office for the fees that we intended to deliver to the meeting tonight. I have it here, and it was made out in the amount of $330 for this fee. So I'm only making these comments to suggest to you that the application itself, I don't think is deficient. There are some issues relative to the delivery of the fee, but that was as a result of, frankly, the Zoom meeting taking precedence over an in-person meeting. And if Mr. Felice, you want to add to my commentary, please feel free.
Thank you. Go ahead, Mr. Chairman. Were you going to say something? Okay. For the record, John Felice from Boundaries LLC. I'm a licensed land surveyor. my office prepared the plans that you have submitted with this application. We did not prepare the 2018 plans. Those plans were prepared by another firm. That firm, the engineer from that firm has retired, and we have picked up where they have left off for strategic properties and Rawson Materials. So the plan that I have in my possession from 2018 delineates the pond. The northerly portion of the proposed pond was within the upland review area and has been excavated. The revised plan, or the updated plan that we've provided, identifies what the limit of that regulated area was in accordance with the 2018 previously approved plan. The work that we're proposing by this plan is outside of that jurisdictional regulated area boundary as it was identified on the 2018 plan. This activity takes place within an area that was an upland that was to be excavated to create the pond, and we're extending that into the town of Putnam by about 1/4 of an acre to the south. You have the plans and you're all familiar with the site. One of the things I'd also just like to know is Margaret had mentioned the outlet. The pond doesn't have an outlet. It has an emergency spillway, so that if the pond were to receive enough surface water or flow from potentially a large storm event, that there would be an emergency spillway on the north edge of the pond. It's just barely shown on this sheet, right at the very top of the screen. That emergency spillway was in the original design and has been constructed. So it doesn't change the outlet of the pond because there is no outlet. It's just, there's an emergency spillway. The expansion of the pond is going to create a larger storage area and would allow more water to accumulate in that pond prior to ever reaching that spillway level. But I just wanted to note that it was important. We're talking about adjacent wetlands to the north that is of concern to the commission, and understandably so. But there is no outlet to this pond. That's an emergency spillway. Other than that, I believe Attorney McCoy covered what we're proposing to do here and the reason behind the application in the way it was presented. I'm not going to take up the discussion between your local land use commissions. However, again, the activity that was proposed here is outside of the regulated area as was determined with the original permit that is still in place, and therefore that is why the application was submitted in accordance with the requirements for jurisdictional ruling.
I have one comment about the fees. The jurisdictional ruling fees are 240, not 330, I believe, as it says here on page 202 of that form. And I also think if you do decide to go, if it becomes an application for an individual permit instead, the fees for that would be different. But you don't need to give us an extra state fee for if you change your application to, well, you know, I guess I still maintain that this form is not used in any other town, and it is meant that on the base form that one project would be chosen, either one of the 5 projects listed: a jurisdictional ruling, timber harvest, wetlands agent approval, permit for individual lot, or a permit for a subdivision. And those each have a supplement form that's supposed to be provided with them, and you provided 2. And so that is not, you know, it's my understanding that's not the intention of how these forms are meant to be used. And it's supposed to be an either or type of filing, although I appreciate what Mr. McCoy said. I just, I don't think that was the intent, because the form says check 1. And so you know, I think that if the applicant decided to apply for a permit rather than a jurisdictional ruling, it would help clarify that. Down at the bottom of the brief project description, it on the base form, it says jurisdictional determination that the recontouring of a small portion of a water body recently excavated entirely in uplands with recontouring located exterior to original upland review area on the property designated above, either one does not invoke the jurisdiction of the Inland Wetland and Watercourses Commission, parentheses jurisdictional determination, or two, in the event that the excavated area is determined to be jurisdictional, the recontouring all occurring below the existing high water line does not have any adverse impact on a regulated resource. And I think where our attorney didn't seem to have completely agreed with Mr. Heller, Attorney Harry Heller's opinion that the pond is not a jurisdictional resource area itself, and that it is a water course. And so that seems to be a point at which our attorney seems to disagree with the opinion offered by Attorney Heller. And so we have forwarded this application to our attorney, and I recommend that no action is taken until we hear from him and hopefully get some clarification and possibly some more information about, the potential for a bigger pond to, I have a question about whether or not the emergency spillway, which I shouldn't have called an outlet, I suppose, if John Foley's says it's not an outlet, it's an emergency spillway. I'm just wondering whether that emergency spillway is designed for the pond being at the bigger size now. Sort of an engineering question, I suppose. And if we have a flood, is there a potential for more water to, enter one of the 10 top most important wetlands in town? So we have some questions, and I think that I don't recommend any action by the commission tonight until we get some more information, clarification, and opinion from the attorney, I suppose, is what I sum it up.
Commissioner Dustin, your mic is on mute. You're still on mute.
I reverted to mute. So Margaret, if I understand you, first of all, I have a question of clarification. We can't receive this application at this meeting, can we? Because this is not the next regular meeting following the date on which the application was submitted.
Well, it would be received by statute if we had all the components, and we don't have them, although, it isn't clear to me what the fees will be if we get a revised application.
Right. And the second point from I gather from your comments is that given the concerns that you voiced, that I think some commissioners share, the better course for the applicant would be to submit an application for an individual permit, so that those concerns can be addressed, and hopefully we would receive more information bearing on those concerns. Do other commissioners have thoughts or questions they'd like to voice at this time?
I have a question. I have a question for the applicant's representatives, as well as an observation. Was or was not the completion card in the possession of the applicant? And was it or was not it submitted by the applicant stating that the work was completed? Yes or no?
My answer to that is no. That card does not.
It wasn't in their possession. They didn't submit it, so it was a mysterious submission.
No,
that was the question.
In fairness, your question was this in the possession of the applicant? Was it submitted by the applicant? And does it indicate something? And what I'm saying no to is that it does not indicate that the work was completed. It indicates a proposed date that it will be completed.
I got the,
So the date was predate. My understanding, at least according to our representative, and again, to be clear here, that the card was received after the date of completion, that date being December of 23, which was post the completion. So reasonable person might conclude that it was in fact completed and was submitted by your applicant.
Except this, the card itself is not dated by the applicant. So I don't, to be perfectly honest with you on the record, I don't know when that card was filled out.
Okay. But of course, I guess our procedures would dictate that we date stamp materials that are received by the office. So perhaps we should explore that. But as the information provided to us by our representative was that it was. So that's one point. But moving on to another point, the question of public notice. Margaret, just to help inform the applicant, are minutes not posted in the public record a number of days prior to this meeting? Or the agenda, I'm sorry, the agenda for the minutes for this meeting. Is that fact true? Margaret?
yes, the minutes were posted.
5 days, 7 days? What is the time frame?
Gloria has 7 days to get them posted from after the meeting.
Okay, so I read from the minutes, which I happen to have a copy of, which are in the public record, which were posted to the website, and it stipulates that meeting agenda Tuesday, November 12th, 2024, 7 p.m. via Zoom online meeting portal. Counselor, you stated that you just learned of this fact that it was on Zoom. I find it somewhat offensive to this commission that you would make a statement like that without at first apologizing for the fact that you overlooked it perhaps, or it was overlooked by someone on your staff. And now you come to us saying, well, we didn't know about it, therefore we want to submit our check. That's one observation, unless you would like to restate your position on that.
I'd be happy to offer as an apology if the expectation was that we had no way of knowing this prior to today. I'll apologize for that, because obviously if it was posted prior to that, I personally did not know, and I was the person attending this meeting, and
Right.
I personally did not know and had a check ready to hand deliver to the town council. So,
Okay, thank you.
And that is an apology. Thank you.
Because I was confused there. Another point here was our attorney. We do of course want you're the applicants, you're the applicant's counsel. Of course, the commission wants to be informed by its counsel, and unfortunately, that information has yet to be provided to us. So, we're at a disadvantage, and we certainly wouldn't want to make a decision on such a weighty matter without full assessment of all the subject matter experts. Amongst those would be the legal implications. So just for my fellow commissioners and just my personal observation, those are the concerns I have, and I support and affirm the recommendation of our chair that we should defer this matter. Thank you.
Mr.
If I
Chairman,
might,
Commissioner
I'm sorry.
Milano.
if I'm not mistaken, this activity is going to impact Putnam, right?
Yes.
And I believe in those cases, we often have to notify the town and have a public hearing, which would be another reason this might be better served as a separate application.
Thank you for that comment. Any response?
Well, I will certainly, I have it on my list of things to do to notify the Putnam Town Clerk tomorrow. Whether or not you decide to hold a public hearing in the interest of the good of the general public is up to the commission, but notifying the town clerk doesn't necessarily come along with a public hearing. I guess I'm confused about why they're asking. I know that Attorney McCoy tried to address why they applied for both a jurisdictional ruling and an individual permit, but the fees are different, and they seem to want to pay the fees for a jurisdictional ruling, but not the individual permit fees, which are different. And usually I think higher. And um, I think this commission feels that what would be appropriate is just one permit for an individual application and not the jurisdictional ruling, because the pond, despite Attorney Heller's opinion, seems to be a water course, and our attorney seems to agree that the commission, because you originally had a permit and created a water course, that the commission could, if our attorney disagrees with Attorney Heller, our commission seems to think that it possibly we need a new permit, so because you're increasing the scope of work in the water course. So I'm just offering this as an attempt to try to help give a little bit of direction moving forward.
Thank you. Other comments?
Are you inviting comment from the applicant at this point?
I am most certainly, yeah.
Okay. I think to answer the question about the alternative application, so that the commission is fully aware. I've been practicing law for a little over 45 years, and it is not uncommon to do applications in the alternative. And the reason for that is because if you do an application on a single issue and it's determined that that issue is not appropriate, you end up doubling the amount of time for an application by then going back for an application on the other issue that can be raised. By doing them in the alternative, you give the commission the ability to look at it from both perspectives and determine which is the appropriate action to take. And I appreciate the fact that the form indicates check one box, but that may be a classic form over substance, because I think ultimately the question is, first of all, is this jurisdictional? And if it is not jurisdictional, then we move on down the road. If it's determined that there is a jurisdictional issue for which a permit is required, then at that point the commission can consider the merits of that permit application. So I'm not trying to be stubborn about the alternative application. I'm just suggesting to the commission that it is not an uncommon practice, and that directing us to do it exactly that way may create an additional problem that we can avoid by doing it in the alternative. Mr. Heller and I will be discussing this matter over the next several days, but I want to be clear that I still believe that that's a procedure that is still appropriate for this particular application.
I got a question about the fees. Are you only paying the fee for the jurisdictional ruling?
No, I'll be happy to consult with your staff as to what the appropriate fees for both applications or the alternative applications are. And we will make sure that we pay exactly what we're directed to pay.
Commissioner Dustin.
Commissioner O'Neill, thank you.
Thank you. Yeah, appreciate the insight provided by Mr. McCoy on the with regard to the rationale behind checking the multiple boxes, and perhaps for all involved, it'd be helpful in the future to provide an editorial comment with the application or cover that expands on the rationale behind multiple checks. I think that seems like a structural component that may not have been present or in the past been an issue. But as our agent points out, it certainly creates a quandary, a dilemma for, which is it, how much was it, and where should it go? Never mind our discussion about funds. So that's a good point. And, it's like anything else with your 45 years of extensive experience. It's certainly helpful for this commission to have that insight. So perhaps the discussion and background and history behind it, as well as the alternative, would be could have helped prevent confusion. Thank you.
And can I have a question for Attorney McCoy? Are you expecting that? I mean, is one potential, if you apply for both things at once, that you're going to get both a jurisdictional ruling and a permit for an individual individual wetlands permit? Is that one possible outcome of your alternative application?
No, I don't think it is. I think to the extent it's not jurisdictional, there's no permit required. To the extent that it is jurisdictional, then a permit is required. So no, I don't think you end up with both. I think it's one or the other. That's exactly the point.
Well, if you got a determination in number 2, as spelled out by Attorney Heller or whoever prepared this application, in the event that the excavated area is determined to be jurisdictional, I mean, the commission, when you ask for a declaratory ruling, one possible outcome is that the commission is going to say that the work is jurisdictional, correct? They can say that it is or that it isn't jurisdictional.
That is correct.
And so if they deem that it's jurisdictional, then you would get your ruling, your declaratory or jurisdictional ruling, and you would also, that would imply that you need an individual permit.
That is also correct.
So you're applying for 2 permits, which at once on the same form, which is not something we've ever seen before. These forms only date back to July of this year.
So my sense, Margaret, what we're saying is that our application structure does not accommodate what Attorney McCoy is describing as an alternative application. And the rationale behind the advice that we're giving the applicant is that it would be safer, for lack of a better word, to apply for an individual permit. And in considering that application, the commission may decide that there is not a significant impact on wetlands and grant the permit. And
in the meantime, we need to hear from our attorney. So I'm not sure. I think we've covered as many bases as we can, unless someone else has got something else to say.
Mr. Chairman, I'd like to just add, we're talking about jurisdiction, non-jurisdiction. The application was submitted to cover both. And the alternative is that if the commission finds that this is a jurisdictional wetland or watercourse, that we would need an individual permit. I think the underlying issue that we need to address is, does the commission believe this is a jurisdictional wetland? I'm from the discussions, I'm assuming that you may. However, we don't believe it is, and I think until that determination is made, an individual permit and the data that would support that permit is going to be kind of tough to circle around or dial into. I will say that the town of Putnam was mentioned. I met with the enforcement officer in the town of Putnam. They thanked me for providing them the plans that for the activity that we were going to be conducting, determined that it was non-jurisdictional, thanked me, folded them, put them in their files so that if a neighbor called, they could identify to those persons that, yes, in fact, they were aware of the activity and it was non-jurisdictional. So in terms of Putnam, that was their take on this project.
Do you actually have a permit or a jurisdictional ruling, John, from them?
I was told it was not necessary. I was thanked for the plans and they went in the file.
Right. I talked to Bruce too, and he told me that he did the same thing.
Right. So that's, so until this commission decides that it's jurisdictional, whether it's a ruling or an individual permit, I think we need direction actually at this point as to whether or not you feel this is jurisdictional. Attorney Heller prepared an opinion letter as to why this would not be jurisdictional under DEP policy and Army Corps policy, and based on correspondence, I believe that opinion was rejected by town staff, by Margaret, but we don't have a direction from the opinion. And although Attorney McCoy has been practicing for 45 years and is very knowledgeable, and your town's attorney is a very knowledgeable individual, it's up to the commission to decide whether this is a jurisdictional body of water or not.
indeed, that's true. I do not think this commission is prepared to do that tonight.
Okay, and that's great. If that's the response, that at least leaves us in a position where we know where we're going forward. Thank you.
Thank you.
And so the record's clear also, you happen to have very competent attorneys representing you. That firm is a very good land use firm, and I would invite you to share the opinion. I would invite Margaret to share the opinion that Mr. Heller authored specifically with Attorney Roberts and or Attorney Slater, whomever in that firm is going to be handling this.
Yeah,
It has been shared, has it not, Margaret?
yes.
Yes. And it's been questioned not only by you, but by Attorney Roberts.
Right. And when we got this application, we immediately sent it to Attorney Roberts for more advice. And so that's where we stand. And I'm not, it's, we just can't make any decisions whatsoever tonight. And it isn't, it's because it came in on a Friday after 4, and then we were closed on Monday. It wasn't received by us until the day of the meeting, and so we need some input from him on pretty much all the aspects of this application. And I apologize for the timing of that. The land use department advised I know that they Cindy sent a letter certified to I think to Attorney Smith, and I don't know if she even received that yet now. And I was concerned about that when I saw I asked for a copy of what Cindy sent to Attorney Smith and saw that it was certified and asked to have it emailed, and I was told no. And so for that reason, I attached it to the email that I sent with Christopher Dustin's email to everyone involved so that you would understand what we were talking about in the interest of transparency and trying to communicate in a timely manner. Because knowing that certified mail takes a long time to arrive, I don't know if Attorney Smith even received the certified letter yet. So I don't pretend to know more than an attorney, but we will rely on what Rich Roberts and Ken Slater have to say and try to do the right thing.
Indeed. So the commission will take no action on this tonight. We will await some further information and perhaps some further clarification as to what the next steps might be. And I thank both Attorney McCoy and forgive me, it's late. The name of the person who prepared the plans is
John Feliz.
John. Thank you. We are very grateful that you're here and sharing your perspective with us, and hopefully
Mr. Dustin, could I ask a question, a clarification on the drawings?
Certainly.
Certainly. In the original set of drawings on the south side of the pond, there's a definition of a 20-foot by 50-foot paved and curbed equipment, parking, and fueling pad, which does not have a reference shown in the new set of documents, which would be in the area of excavation. I'm just wondering if that's something that has to be demoed or was never built.
You're on mute.
Now I realized I had to unmute myself. That is not existent at this point. The construction activities and the equipment are currently on the Putnam side of the line, but that paved area is not located on site currently. Our first involvement on the property was in January of this year for the permit renewals, and you're correct. It would be in that general vicinity of the work that's being proposed, but it does not exist currently.
Thank you.
And one last thing, earlier tonight, one of the representatives for the project said that we are all familiar with the site. I only started working here in May. I have never been on the site. Our chairman is relatively new. Chairman Dustin, have you been to the site?
No, I have not, and I would like to see it.
Yeah, we should have a site walk.
I agree.
How would Attorney McCoy and Mr. Feliz feel about a site walk?
I think that's perfectly appropriate. the question becomes whether or not you would do that after accepting an application, and then setting it up at the meeting at which you accept that application. Because as I understand the process tonight, the application is not being accepted. So I think procedurally you'd have to accept the application before doing a site walk. But I think it makes sense.
Well, you know, we want it to be received by statute, as do you, and it's a gray area to. I apologize that that's a bit of a gray area to me with the timing and so forth, and so hopefully after we get some clarification, we can proceed and get something scheduled, received and scheduled.
Yep.
Margaret, in the meantime, if it's helpful, I can provide you some photographs that my field staff took during the survey aspect of this. I can send you those tomorrow if you want to distribute those to the commission members.
All right, and now because the subject property has some mapping by the Natural Diversity Database on it, but it's not in this area exactly where the pond is.
Correct.
How do you feel about whether or not that would trigger the need for a review by the NDDB? Just out of curiosity.
At this point, our opinion would be that it doesn't trigger review. It's outside of the NDDB area, and the work that was done in that area was the 2018 permit. And that portion of the pond has been stabilized. I don't really think there's any. I don't think there's anything in what we're proposing now that would trigger a submission, particularly because we're outside the area.
Okay, just thank you for that.
I did look at that limit, I'm sure just as you have, to make sure that we were outside of it.
You know, I guess in my mind, it would be helpful if we had, and you know, maybe the attorney can comment on this, whether or not it would be helpful to have an engineer just prepare a statement as to whether the spillway created for the smaller pond would need to be beefed up or will be big enough for the larger pond. And so the original pond was 6 plus or minus, I think slightly over 6 acres. How big is this total pond going to be? Now the bigger pond, if it becomes all one pond.
We're adding an additional 1.6 acres.
1.6.
Correct. So it would be 1.6 acres an increase. That includes the Putnam portion of the pond. That's contained in the narrative at the upper left corner of the sheet.
So can you tell me what the total pond size will be if it gets?
If we were 6 and additional 1.6, then it's going to be 7.6. I'm taking you at your information on the original permit. I'd have to look at those plans. I have them here, but I mean, yes, the original surface area of the pond was 6.1 acres. We're adding 1.6 acres, so we're looking at a total of 7.7 acres.
Okay, thanks. That's helpful.
Any further questions, comments? If not, then again, I'm going to thank our representatives and thank you, commissioners, for sharing your concerns. We look forward to a site walk and to considering the application and any further information we can gain.
Thank you very much.
Thank you.
Thank you.
Good night.
Good night.
Thank you.
Shall we proceed to the next item for discussion, which is how many years of wetlands delineation is considered to be accurate? And I believe, Margaret, in your report, you consulted with the town attorney, and he has recommended a 10-year. The reason being that it coincides with the length of time that our permits are in force.
Right, I don't have really anything to add to that. I did prepare a draft policy statement in case the commission decides to vote on it tonight. It's back there in the, I think it was in the document, the Zoom docs,
In the supplemental or the original Zoom doc?
the original.
Okay. Probably the trick bouncing back and forth between.
Towards the bottom, I think, must be towards the end.
Okay.
Let us know when there's an opportunity to discuss this subject.
Yeah. Didn't remember seeing this. Oh, yes, it was 187, right? There you go. It is the policy of the Thompson Inland Wetlands Commission that wetlands delineation should generally be deemed to be valid for 10 years following the date the delineation was performed in the field.
You know, I've been thinking about it since attorney Roberts shared his suggestion with us, and it might, I'm not forcing or pushing you folks to do anything tonight, because I was thinking ever since he said 10 years about the legislative extension, which made a lot of permits good for 14 years. And it might be something, it makes me a little bit uncomfortable knowing that someone could come in and say, how can you tell us our delineation is only good for 10 years when our permit is good for 14 years? And so maybe we should hold off on this and mull that around for a bit before doing anything, if anything, about this question.
Okay. Well, if it does not have any particular urgency for you at this point, unless it does for other commissioners, I'm happy to sit on it while we reflect. Any commissioners have other thoughts?
Commissioner Dustin, I have an observation on that point.
Yes.
I thought about it as well, and these are always problematic. How long, what is it? I mean, we go back almost to biblical times as to how long something should be in place, 5 years, 7 years, the life of whatever, the monarch. But I kept thinking, I was thinking parametric, I see a lot of things that are parametric, the lesser of, or the greater of, the duration of so many years, or the approved permit or something, right? And this way, it's not like it's going to constrain the project. However, it's not going to be an open-ended item, as as Margaret points out, and hydrology and the area may change. So that's something to keep in mind. And so as I keep wondering, do we have permits that we issue that the work must be done greater than or less than 10 years or more than 10 years? And if not, then would it not, just a consideration, but a time that is equal to the approved application, the lesser of the time, the application, or X number of years, or 5 years or 10 years?
Well, it's interesting that you raised that, because in Massachusetts, permits are always good for 3 years, and that is the life of them saying that the delineation is good for 3 years. And now, looking at this project we just talked about with the pond, what is building a 7.7 acre pond next to a wetland going to make that the delineated wetland change? I really don't know, but right now, some of our permits are actually good for 19 years, because the original permit was good for 5, and then they were legislatively
Right.
extended for 14. And then
Right,
you
so-
could also get an extension of 5, which would make 24.
Right. So that's a problem. That came up through COVID, and it gave these built-in extensions, which created all sorts of havoc there. So, the lesser of, again, if you put the caveat, the threshold of the lesser of the approved amount or X number of years, notwithstanding some statutory changes. Because what we don't want is something out there near perpetuity. Although people may live for a long time, the environment changes quickly, and so for that reason, so I think you're maybe wise to defer and contemplate it better. But I would think something parametric, something that's tied to the approved activity, and no matter what's passed, no matter what's changed, because you have this thing that we had these permits that are 3 to 5 years, and all of a sudden unilaterally the legislature comes along and gives you 10 more years, and you find yourselves with a time horizon which is far beyond any contemplated by the commission. And I hope that it wasn't the intent of the legislature to unilaterally usurp the authority of the federally granted Inland Wetlands and Watercourses Act and those commissions in the towns through that mechanism. So that's my concern here. So I'd keep it shorter than longer. You can always come back for an extension. So that's just some food for thought.
I noticed today reading an NDDB report for the 17 Bacola site that it's only good for 2 years, her review, and it says that if the work doesn't start within 2 years, you have to reapply. And our permits, traditionally written by Marla, said that the permit was good for 5 years, but you have only 2 years to perform the work. And I find myself feeling extremely uncomfortable about trying to tell an applicant that by law the permit is good for 5 years, but you have to do the work within 2 years. So maybe
a commencement date. There wasn't a commencement date within 2 years. Was an interdependent component. In other words, a period for X, but if it once commenced, it must not exceed a number.
I think the wording was something to the fact that if your work must be finished within 2 years of starting it.
You have 5 years to start. Once you start, it takes 2 years then.
I don't think so, because that would be a 7-year permit. But
well,
in any case, I think it'd be safer to stick to what the law says, which is the wetland permits are good for 5 years.
14 years.
Instead of trying to say, oh, we'd really like you to do it in 2 years, but you have 5 years. And so I just thought it was interesting that, and maybe,
right.
that because I think some folks come in with a project purposely limiting what's shown, and then later on they're going to ask to do something else. And I kind of like the idea that NDDB is saying, well, you have 2 years under this review, and if something changes, then you have to come back, because they recognize that species habitats change.
Right. But delineating the wetlands is another dimension as well. So there's an additional cost associated with it. So
it would be interesting to find out about what impact, if anything, creating a pond on the edge of the wetlands would have on its delineated edge.
All right. Well, anyway, those are my thoughts. Thank you.
Good thoughts. Thank you, Commissioner. Very helpful, I think. So we'll continue to ponder this one.
Okay.
You're comfortable with that. That brings us to any additional citizens' comments on agenda items. We welcome them at this time. If not,
I think I could answer Ms. Clark's question.
Oh, okay. Did you want to wait for that until we get to correspondence?
Okay, sure.
Okay, that's where it falls in the agenda. We can quickly talk about the budget, or at length if you prefer.
No. Commissioner Langer here. All of our line items are in the condition that they need to be, at the exception of the office supplies, which does currently record the monthly cell phone, which was not initially covered in the budget. As briefly discussed before the meeting started, I'll start working on the 2025 or next year's budget and have that worked on for some reporting on progress in December.
Excellent. Thank you. Thank you very much. Any further questions or comments about the budget? If
No.
not, wetlands agent report. I think we've been working through your report, Margaret, as we've been going along. I will just note that you're signing off on the Madison Avenue Road acceptance. I think that's the only item in your report that we have not discussed.
And I'm going to be soon going out to review the Jason LaValle's project at Donovan Drive to recommend whether or not the town accept it as a road. And I'll look at it both from the wetlands perspective and the conservation easement perspective.
Okay, excellent. Thank you.
You're welcome.
So this brings us to correspondence, and this is the item that Ms. Clark had a question about. So Margaret, perhaps you could, you're having to do a lot of talking here tonight. So this is an initiative coming from the Conservation Commission, is that right? And they would like someone from our commission to join in this?
Yes, and the list of people it was sent to was prepared by Chairman Judy Rondo of the Conservation Commission. This is going to be a subcommittee of the Conservation Commission, and she gave me a list of boards, commissions, and committees that she wanted to have members invited to join. So that's the answer to how it was decided who got the letter.
Okay, thank you. So this initiative is coordinating our efforts and our information, our inputs and our outputs regarding sustainability townwide. Does that sound right?
Yes, and anyone who wants to attend the Conservation Commission meetings can certainly have public comments too, and if someone's feeling left out and we let Ms. Rondo know, we could always ask her if she's, if she feels like someone got left out. I'm not sure exactly what to say. Or
perhaps it's something that as it's up and running can be widely advertised so that the citizenry is aware that this is something we're doing.
Yeah, maybe it would be good to ask the question at the next the November Conservation Commission meeting, which is coming up quite soon.
Okay. The letter that you've shared asks for one member of our commission to volunteer. I think I've already indicated to you that I would be happy to do that, but I also don't want to put myself ahead of any other member of this commission who is eager to do so. So I will defer. I mean, I have an interest in this topic, and as the chair of the commission, I'm happy to represent it, but I also I don't need to put myself first.
I think you'd be a great candidate, Commissioner Chair.
Thank you, Commissioner O'Neill.
I second that.
Okay, thank you. Any other questions about this item? Okay, if not, this is the home stretch. Signing of Mylars, we have none. Comments by commissioners? Anything remain unsaid? I want to thank you for, in particular, Commissioner O'Neill and Commissioner Morano for your heartfelt comments regarding the dynamic between our commission and current dynamic and other town commissions. And hopefully my meeting tomorrow will begin to address some of those concerns, and perhaps we can get things on a better course.
I have a comment,
Please.
no others. Thank you. One of the things that I always have to remind, I work with a lot of folks that are in subject matter experts in my business activities that are subject matter experts, but ultimately, as was pointed out during our discussions or meeting tonight, it was pointed out by one of the applicants that it's our decision. as commissioners to make these things. And but that's so true. And I just want to reinforce the point that whether they're an engineer, whether they're a environmentalist, whether they are a citizen, whether they are a member of the bar, esteemed member of the bar, they aren't making the decisions we are. And we consider their applicant, the context of their word, the argument, the case they make, but ultimately it's our decision. And I'm always don't want one to overshadow, and I've heard many times in different commissions saying, well, the engineer said this, okay, fine, that's the applicant's engineer. You know, what does our engineer have to say? Or the attorney said this, well, what does our attorney have? So I think it's important that we consider all those subject matter experts and then make an informed decision. And, you know, it may be supported by that or not, but never forget that, because at the end of the day, it's our call. And, you know, if you're in a business and you run a business, you know, you can have all the accountants and all the rest of them telling you what to do, but you call the shots, and if it's a loss, you pay it. So just that came to mind in our dialogue tonight. That thank you very much, but you know, I'll get my attorney's opinion as well, or I'll get my engineer's opinion, or I'll get my environmentalist's opinion, and just let's never forget that, because that's the oath we took. And you know, we may be wrong, but let's consider all the facts. And if we don't consider all the facts, then we've dropped the ball there.
One of the sad things is that we don't have the ability to make applicants pay for a peer review in this town. The last town where I worked in Brooklyn, our ordinance allowed us to charge them the cost for example, a hydrologist when someone was digging a very deep gravel pit in NDDB habitat, and we got the prices for the work and they paid for it. And we're kind of, our hands are tied here as far as hiring an expert to tell us what are the impacts on the wetlands, for example, downstream of this pond and one of the 10 most important wetlands in town, if the pond is made larger. And
well, let's do that.
we don't, well, it would take changing an ordinance, and it's not, you know, for a selectman, it said, you know, I don't think it would be palatable.
Well,
but
a proposition for you would be, if you want us to consider that, we need more information. We can't fund it. If you'll fund it for an independent third party to do it, then we'll do it.
And
or we'll consider it. And that's a proposition. It doesn't say you can't do that unless I'm missing something. It just doesn't say we can explicitly can. And this is where the world of commissions versus the written word versus what makes sense. You know, how's this? We approve it. We never considered it. We find out a major economic environmental catastrophe. Now that's a consequence. So I like your point. Let's request it and ask them to fund it. If they refuse, then we note it. Then as a commission, we've done everything we can within our fiscal boundaries to exercise our responsibility. So I wouldn't allow that to be a limit. I would look at that as a challenge, an opportunity. And if it doesn't work, then we get it written into the statute or
the advantage is that the town gets to pick who is this expert. And unlike, for example, if we asked these folks with the pond project to give us some expert's opinion about the impact on the downstream 10 most important, one of the 10 most important wetlands for the wildlife habitat and the flood zone, and etc., they're going to pick somebody who's going to say what they want, unlike us making them pay for an impartial party who may say that may say they're right or may say they're not right.
Of course. But my point is this: I do this all the time, where I have a opinion we need on something. Says you want us to do it, fine, we'll consider it. It's beyond our expertise. It'll cost. We will have to get additional subject matter experts that cost $5,000 or something. And if you want, we'll include that in the application fee, or if you'll volunteer to do it. So what I'm suggesting, Margaret, is it doesn't say you can't do it. We can ask the applicants to do it and ask them to fund it, and we'll pick the expert, and they'll report to us. They fund it. Now, if they refuse, okay, noted. But we've done everything we could within our current constraints, and we may not be able to compel them today. So perhaps in the future we will be able to, and that's something to do in the future. And that doesn't have to be 10 years from now. That we're talking months. But I take your point. But I say push the boundaries. Let's push the boundaries. Say, look, we'd like to have this. We'd like to have an expert. We have an estimate, it would cost $3,000 or $5,000 for someone to do it. We'd like you to fund it, but the report will be to us. This is part of a non-required or a voluntary offer by your applicant. Now, I know that the applicant maybe have very meager means and have no resources to provide to fund this, but in some cases, maybe the applicants do have substantial resources, and given the gravity and impact their projects have on the aquifer and on the inland wetlands, maybe it makes some sense. But I'd rather be that guy says, yeah, they pushed hard and they tried to get all the information they could, but we refused them, rather than to say, we have an environmental catastrophe and you never even asked, okay? Maybe I'm being a little dramatic, a little hyperbole here, but you get my point. Thank you.
Yeah, and it's not just those kind of experts, but every other town in the area that I know of has a peer review engineer. In Brooklyn, we used someone from NECOG, and that is a terrible crippling effect on our commission not to be able to, if somebody comes in with an application for another 24 lot subdivision with a lot of drainage in the road, we're not qualified to review that type of work, and we don't have any money to pay Janet Blanchett to review it. And since she does most of the review work in town, but on the other hand, what will we do if J&D come in with a 24 lot subdivision with all that road drainage, and we don't have anybody to give a second opinion on their work? None of us is qualified. It's really needs to be in the budget.
Well, I was going to say, Commissioner Langer, I hope you're listening. Here's a budget item, and
You
given
got it
these
right in front of me. I'm looking at it.
I'm going to agree with Commissioner O'Neill. I mean, you've mentioned this before, Margaret, and I think we can try to be creative when it comes to moving it forward and seeing what we can do, perhaps incrementally, and to move on this. And more broadly, Commissioner O'Neill, not that I want to have the last word here, but I will not only echo, but turn up the volume on what you were saying. It's not only our prerogative to make these decisions and to make them wisely, it's our statutory responsibility.
That's it. Let's do it. Even though we have the funding, let's try for it. Why not? Go for it. Here.
There we go. Well, on that note, if our business is, if our work is done here, I will entertain a motion to adjourn.
I'll offer the motion.
I'll second it.
That motion is made by Commissioner Langer and seconded by Commissioner O'Neill. All those in favor?
Aye.
Aye. All those opposed? I will see you all at our next regular meeting in December, whenever that is.
Yeah, if anybody knows they're not going to be able to make that meeting, please let me know before the meeting if you can, just so we know we'll have a quorum. Thank you all.
Margaret, one last question. Based on the way that we ended that pond project, is there a chance that we might schedule a site walk the week prior to our next meeting? Or is that? I
think it's yet to be seen. They seem to want to, their comfort level was making sure that their application was going to be received.
Okay.
And I'm mystified by the process that they're taking, and I don't think that they would let us do a site walk at this time.
Okay. Thank you for that clarification.
Okay.
That's why we need that drone.
Another budget item. I don't know if this is all, have we adjourned?
We need to adjourn. So we made an agenda. I guess you just call it. We had made and seconded it, and we said aye. So I guess technically we've got it, don't we?
I think we said aye. Everyone said aye. Yep.
And there's no opposition, so we are adjourned.
Okay. Thank you all.
Don't forget to hit the turn off, but the recording.
There we go.
Okay.